Good evening, everybody. My name's Nicola Lennard. I'm one of the medico-legal advisors from the MDU. Thank you very much for joining us this evening. I know you're all incredibly busy at the moment, so I am grateful for you joining us here this evening to look at the new GMC guidance on decision making and consent. I am pleased to say that I am joined this evening by several of my colleagues. We've got Sam Bell, Ed Nandasoma and Jerard Ross, who are going to be here beavering away while I'm talking to you to answer any questions that you want to put to them. Please do try and get your questions in nice and early. It's kind of difficult to get through all of the questions if we have everybody waits till the end, so do get them in nice and early and then hopefully we can get back to you with our responses. I'm sure that you'll all be wanting to know how you can get a certificate of attendance in relation to this webinar. That will be sent out to you over the next week. And you might also want to be aware that a copy of the webinar will be put on our website, again, hopefully within the next week or so. So without further ado, we'll move on. So the aims of this evening really are to have a look at the law and the GMC guidance on consent and see how those have developed over time. In addition, we're going to look at the new GMC guidance on consent, which came out in November of last year, and we'll just have a think about how that might be implemented in clinical practice. Thought we might start just by having a look at the definition of what consent is. You'll see from the date at the bottom of this slide that this is a relatively old definition, but there hasn't been an updated version since then from the Department of Health. It emphasises the importance of consent being a voluntary process and that there can't be any coercion. Equally, we have to think of consent as being a continuing process, and that's particularly important when we're thinking of courses of treatment. So why is consent so important? I'm sure you'll all agree that the doctor-patient relationship is wholly based on trust, and for patients to give us their trust, it is absolutely essential that they have some control over what we do to them. So to me, consent is actually, it's hugely important to that whole doctor-patient relationship. Patients have a right to make decisions about what will happen to them, and that's the principle of autonomy, which I'm sure you're all aware of. Clearly, there is a legal requirement for consent as well. If you undertook a procedure or provided a treatment to a patient without their consent, there is a possibility that that might be an assault. So again, there's that legal requirement. And of course, the GMC has produced quite a large amount of guidance in relation to consent. So there is an expectation from our professional regulator that we will seek patients' consent prior to providing any treatment or intervention. It's interesting that the amount of information that we need to share with patients has changed considerably over time. I'm sure you've all been aware of the Boland principle and this reasonable body of medical opinion informing us as to what's appropriate to disclose in terms of consent. But as our relationships with patients have changed and we've become less paternalistic, we've moved from what the reasonable body of medical opinion wants to start to consider what a reasonable patient would want to know and what the patient in front of us would want to know. So it's easy to see how, although the body of medical opinion will have changed their opinion as things have gone forward over time. When a claim arises about consent, whether adequate information was provided to an individual to give consent really depends on it's a matter of evidence. And so when providing information to patients, you have to think about, can you evidence what information you've shared with patients? Have you focused on what the patient wants to know about the treatment or the intervention going forwards? Always something worth thinking about as you're obtaining patients' consent for any form of treatment. So we're going to have a look briefly at the history of consent and really have a look at how it's evolved over time. We're not going to go into a whole load of different legal cases because that's really not the purpose of this evening, but it's helpful just to sort of refresh our memories of where we've started from and where we've got to. So we're going to go quite a way back in time, back to 1985. I have to say it was the year before I started medical training. So it kind of shocks me a little bit, the details of this case and the judgment in relation to this case. It doesn't seem that long ago for me, but that's how time flies, isn't it? So many of you will be aware of the case of Sidaway. Mrs. Sidaway was a lady who had a chronic pain problem, and she consulted with a neurosurgeon who offered a procedure to try and reduce the pain. Now, when she was being consented for that procedure, the neurosurgeon warned her about the 2% risk of nerve root damage, but she wasn't told about the less than 1% risk of spinal cord damage. Needless to say, she sadly had spinal cord injury and suffered significant disability as a result of that. She made a claim against the neurosurgeon and argued that the neurosurgeon had failed in his duty to warn her of this significant complication. And you'll see up here an excerpt from the judgment. It's interesting that the court held that what needed to be disclosed to a patient was really a matter for the exercise of professional skill and judgment, and as such that the Boland principle should apply, i.e. if a reasonable body of medical doctors thinks that sufficient information has been given to the patient, then that's okay, the doctor's done their job. When you look at the language within this judgment, it's really quite shocking. The suggestion that you don't want to be deterring the patient from having a treatment that the doctor has decided is the correct one for them by telling them about all those nasty complications. Not an approach that I could envisage any doctor taking in this day and age, but it shows how far we've come from that time. The first GMC guidance didn't come out until 2008. Almost 20 years later, and it was quite clear that at that time the approach to medicine and that doctor-patient relationship had changed quite significantly. It's interesting that the 2008 GMC consent guidance doesn't even mention the case of Sidaway in its legal annex, but instead it refers to the case of Chester versus Afshar. And in that judgment, it was said that in modern medical law, paternalism no longer rules, and a patient has a prima facie right to be informed by a surgeon of a small but well-established risk of serious injury. It was clear from the 2008 guidance that the GMC was placing a clear onus on doctors to share information with the patient. And there was quite a number of lists that specify the types of information that must be shared with the patient. When the GMC uses the word must, there is no choice about the matter. You have to do it. It had very much moved towards this patient-centered expectation approach. So the next big wave in the consent story was in 2015. So quite a time after the first lot of GMC guidance. And here there was another landmark legal case And it's the case of Montgomery, one that I'm sure many of you will have heard about. At the time, it caused a huge amount of concern amongst clinicians, and particularly when out and about giving talks on consent, we were met by a lot of clinicians wondering how they were going to achieve this new standard of consent within the constraints of the National Health Service. So, as I'm sure many of you are aware, Nadine Montgomery was from Scotland. She was a lady who was relatively short in stature, and she was pregnant, and she was diabetic. During the birth was complicated by shoulder dystocia, and sadly her son suffered significant hypoxic injury with disability as a result of that. Now, Nadine Montgomery argued that if she had been told about the very small but significant risk of shoulder dystocia and the injuries that can arise from that, that she would have chosen to have an elective caesarean section. Now, this was a case that went all the way through all the courts, initially starting in the Scottish courts, but going all the way to the Supreme Court. And it was in 2015 that we got the judgment. And this changed the legal standard for information to be shared when consenting a patient. So the doctor was under a duty to take reasonable care to make sure that the patient is aware of any material risks involved in the treatment being offered or in any other reasonable alternative treatment. And the test of materiality was dependent on whether a reasonable patient in the patient's position would be likely to attach significance to it, or whether the particular patient, i.e. the patient sat in front of you, would be likely to attach significance to it. So Montgomery gave us the two-stage test for information provision when consenting individuals. What would any patient want to know, and what does your patient need to know? We've got an objective and a subjective element to this two-stage test. Now, as I said, this judgment caused lots of ripples at the time, but the GMC put out a press release at the time which said a doctor complying with their 2008 GMC guidance is likely to satisfy the test for informed consent set out in Montgomery. And so the GMC did not believe at that time that they needed to revise their guidance in light of the judgment. So in terms of the information that doctors need to provide with regards to treatment or interventions, they need to let the patient know of any reasonable risks, and the onus is on the doctor to provide information relevant to their particular patient. In addition, they've got to make sure that the patient is informed of all the different options, including the option of taking no treatment. Now, you might think that this might have led to a huge number of claims in consent, and we have seen consent cases being taken forward, but it's interesting to see that the courts have recognised this very much as the new standard for information sharing, but they've also placed a sort of a requirement on those making claims to be able to demonstrate that if they had been provided with the information they allege wasn't given, that they wouldn't have gone ahead with the procedure or the treatment. So bringing us up to the present date now, we're in 2020, in November, the GMC issued its revised guidance. The guidance itself is called Decision Making and Consent. And I think that's important because as a former surgeon, I know I have a tendency to think of consent in relation to surgical interventions, but this is not the case with this guidance. The guidance is for all treatment decisions, not necessarily just surgical interventions. So be it adding in a new antihypertensive to treat a patient, or be a decision to start an individual on chemotherapy, this guidance is aimed at all of those decision-making processes. And what the GMC have done with this guidance is that they have set out 7 principles of decision-making which clinicians need to apply to the particular clinical context in which they are offering treatment. I think it's helpful just to spend a little bit of time going through those 7 principles, just to make sure that we look at them all in detail. So if you look at the first principle, you will see that this is very much about patients having autonomy. They all have a right to be involved in that decision-making process. Very obvious thing to say, not something that I'm sure that anybody would want to take issue with. The second process places emphasis on it being an ongoing process. It's not a single procedure, and it can be done in multiple intervals, and it requires the exchange of information between the individuals, the doctor and the patient, or the other allied healthcare professional and the patient. The third principle also emphasises that patients have a right to be listened to and to be given information they need to make a decision. I think principles 2 and 3 emphasise to me a really important part of consent, that it's not just about the doctor giving information to the patient, but the whole process of consent requires the doctor to obtain information from patient to understand what their specific needs are and what their expectations are, and then sharing information once they've done that. So it's a two-way process. It's not just a doctor reading out a load of potential complications or risks. Moving on to principles 4 and 5. Principle 4 gives a nod to, in essence, the Montgomery judgment. It's about us finding out what really matters to the patient, what their concerns are, what is really important to them, and making sure that they are also aware of the various different alternatives to treatments, including the option of taking no action whatsoever. In principle 5, we're really looking at capacity legislation, such as the Mental Capacity Act and equivalent legislation from the other regional jurisdictions. It makes clear that capacity is time and decision specific, and that we have to start with that presumption that all adult patients have a capacity to make their own decision. Principle 6, when we're thinking about patients who we have assessed to lack capacity, decisions then need to be made in line with what is going to be of overall benefit to the patient. And we should be involving those close to the patient when making those decisions. And if there is an advocate, such as someone with a power of attorney, then those individuals should be involved as well. And then the final principle makes clear to us that we have to make sure that everybody has a right to get involved in the decision-making process. And even those whose right to consent might be affected by law, they should still be involved. So, for instance, if a patient is detained under the Mental Health Act, it doesn't mean that you make decisions for them in relation to all treatments. You try and involve them as much as you can. So whilst this guidance gives principles, it still gives some examples of information that you must give to patients. Firstly, we've got to tell them about their diagnosis, their prognosis, and any uncertainties in relation to that. We need to tell them about the various different treatment options for managing their condition, and the potential benefits and risks of all of those. Now, I think those are all fairly obvious things that we would all include when talking to a patient about a treatment or an intervention, but the GMC makes clear that we must do so. paragraph 13 goes on to give us additional information that we must discuss with the patient, but these tend to apply to more specific circumstances. For instance, if we're using an innovative treatment, we need to tell them about it. Equally, if this is a research project, they need to know, and they can refuse to take part in research or teaching. Equally, if the patient is having private treatment, they need to know what bills they're going to have to pay. Patients are also allowed to have a right to seek a second opinion, and you can inform them of that. So, what does the new guidance say about Montgomery and asking about expectations of patients? It says that we should try and find out what matters to the patient, ask them about their wishes and fears, find out more about their personal and professional life, and support them to assess the likely impact of various treatment options on their life in general. And we should also encourage our patients to ask us questions so that we can use those to guide us in what we feel or what the patient says matters to them most. And we need to do that prior to recommending treatment for them. In terms of materiality of risks, remember Montgomery says we need to tell them about material risks. The GMC says that we should tell patients about recognise risks of harm that you believe anyone in the patient's position would want to know. And you would generally know that already from your professional knowledge. We then need to apply that particular patient approach as well and find out if there's something specific in the patient's medical history which might make them more at risk of a certain complication. Equally, if there's particular aspects of the treatments that they are concerned about or particular risks that they just wouldn't want to even consider, we've got to ask about those sorts of things. In addition, if there's any risk of serious harm, however unlikely, that would be considered a material risk. And if there are common side effects, we should generally tell them about those and what to do if they occur. I appreciate that saying all of this, that there will be concerns, that there is an expectation for doctors to be providing an awful lot of information and doing an awful lot of almost detective work into the things that make their patient tick. But the guidance is quite helpful in that it makes clear in paragraph 5 of the guidance that not every paragraph will be relevant to every decision that is made. And it requires us to take a proportionate approach to taking consent from patients. It acknowledges that the approach will vary depending on the complexity of the treatment being offered and the urgency of the treatment being provided. It will also vary depending on what has already been discussed and documented as discussed with the patient as well. The GMC expects us to explore with the patient what level of information they need from us, and we shouldn't necessarily assume that they are aware or have knowledge of a certain procedure. We need to discuss those risks objectively, and if we can, provide them up-to-date and relevant data, and try to put that data into context so to help the patient understand how this may affect them. There's also a requirement on us to review decisions, particularly immediately before providing a treatment. It is very clear these days that consent can often be a process that takes place at many different intervals. For those of you in hospital, they might have 1 or 2 outpatient clinic appointments before being seen in a hospital, and the consent discussion will go along through that. Equally, in terms of the GP setting, you might have several different consultations with the patient about options for treatment, and the consent might not just happen at one single go. But if prior to providing a treatment, you do need to review that the patient's consent is still ongoing, check that there hasn't been any alteration in their condition or in their position or in how they have weighed up the pros and cons of a particular treatment. It's particularly important, I suppose, in treatments that are a treatment program plan, for example, something like chemotherapy. A patient's assessments of the pros and cons of that treatment may vary as the treatment progresses, and there needs to be a constant assessment of that. You will be pleased to hear that doctors are still allowed to delegate the consenting process, and it is clear that the GMC is aware that doctors are working very much as part of a multidisciplinary team, and that you can delegate someone from that team to obtain consent from the patient, provided they are suitably trained and competent. However, they do say that you need to make sure that that is appropriate, and you will need to consider perhaps the nature and complexity of the treatment and whether or not there's any uncertainty associated with the prognosis or the treatment itself. Equally, what they do say is that there might be someone within your team who may be better suited to obtain consent. They may have that greater rapport with the patient, and if that happens, if that exists, then you should use that to your benefit and try and make sure that you maximize that therapeutic relationship. There is one caveat to delegation for consent. If you are undertaking cosmetic interventions, then you cannot or must not delegate that responsibility. The senior doctor doing the procedure needs to take that consent in that case. New guidance offers us a few practical tips about obtaining consent. I'm sure many of you will have thought of these already. The use of visual and explanatory aids, be that written patient leaflets, patient information leaflets contained within, say, medication, videos, links to websites, etc. All of those can be really helpful. We do have a duty to make sure that we answer questions fully, but it's okay to say that we don't know. And in fact, if we don't know, we should be saying as much, that there is uncertainty, and discussing that with the patient. When taking consent, particularly in relation to ongoing treatments, it's important to perhaps discuss when you might revisit the appropriateness of that ongoing treatment, and always keep that dialogue open. We'll note the point at the bottom of that slide that consent form is important, but it's not a substitute for a meaningful dialogue. And you'll hear this word several times in the guidance and this evening. Meaningful dialogue and evidencing that meaningful dialogue is certainly a recurring theme, and great emphasis is placed on that. A consent form just with a list of complications does not necessarily give evidence that that dialogue has taken place. As in other bits of legislation, such as the Mental Capacity Act, there is an emphasis on patients being supported to make those decisions, and I'm sure that many of you will have thought about this. You will accommodate patients' wishes to have relatives present. You will try and make it as stress-free as possible, anticipate when they're likely to find the information distressing, share it in a place and time that makes it more easy for them to understand. You'll also note that the GMC says that we should accommodate a patient's wishes if they would like to record the discussion. And I know that's something that causes quite a bit of concern sometimes amongst doctors when a patient asks to record the discussion. But certainly in our experience, it's helpful for the patient who can't always remember what's been said, and it generally assists the doctor as it provides evidence of all of the information that you have provided to that patient. Many of us will have had that experience where a doctor says, yeah, I'm very happy, do the procedure, but I just don't want you to tell me anything about it. I don't want you to worry me with it. In that situation, the GMC says that there is certain information that we do need to tell them, and that includes whether or not the procedure is invasive, about the levels of pain or discomfort they might experience and how that will be managed, and if there's anything that they need to do to prepare themselves for that intervention. Equally, if there is any risk of serious harm, you do need to make them aware of that. Now, I'm sure that in that sort of situation, everybody would try and support the patient, try to explore with them why they are worried about hearing this information, and try to encourage them to listen more. But if they still insist that they don't want even the basic information, the GMC then requires us to form a judgment as to whether or not their consent is valid, and whether or not you can proceed. They say that that's more likely to be the case if the intervention is a well-established intervention and used for treating conditions quite commonly, and that you've got no reason to believe that the patient would not want to be treated. But they do suggest that this can be quite a difficult situation, and that you might wish to take advice from your defence body as well at that point. So things that the GMC want us to think about when obtaining consent for intervention. They want us to have this meaningful discussion and be able to evidence what discussion we've had. They want us to be clear about the scope of the decision the patient is being asked to make, and to make sure that we support all patients in making those decisions. They also encourage us to think about future decisions in cases where that might be relevant. I suppose that is particularly important if you have an individual who has terminal disease and may at some point will require end-of-life care, and having knowledge of what the patient might want towards the end of their life it can be really helpful at that point. They also make clear that an express statement, or they provide an express statement that a signature on a consent form is not enough to show evidence of consent. They give us some reassurances that they want us to take this proportionate approach. The GMC also acknowledges that we work within resource constraints, both financial and staffing wise. They acknowledge that we are working in a multidisciplinary team, and as such allow us to delegate decisions. They also provide us with some reassurance that the guidance will be used when regulating doctors. It will be looked at in relation to the particular circumstances of the individual case. So it's not a blanket one-size-fits-all approach. We often get asked about record keeping. What can you put in the records to say that you've obtained consent? There's no one size that fits all, but if you can document the patient's symptoms and their severity, what their specific concerns are about any treatments being offered, and what their priorities would be for the outcome, and anything that they might wish to avoid. If you put that down along with your discussion of the risks and benefits of the various alternative treatments, along with the option of no treatment at all, then that is going a good way towards demonstrating that meaningful discussion has taken place. I do appreciate that this is not a normal time and things are incredibly busy, and there are additional risks that patients are very conscious about. It is difficult when patients ask about the risk of acquiring COVID. It is important to acknowledge that knowledge might not be complete, or there is uncertainty in that area. But I just wanted to point you in the direction of this Royal College of Surgeons tool, which can be quite helpful in looking at these sorts of questions that arise from patients. So when considering consent, there are a few important considerations that we need to take on board. We always need to think about a patient's capacity to give consent and what we can do when a patient does lack capacity, whose opinion we should be seeking. Equally, there can be difficulties in obtaining consent from children and in young people. It is really important to bear in mind in these cases that there is different legislation across the various different jurisdictions in the United Kingdom. If you have specific concerns, what I would recommend is that you check with your medical defence organisation in relation to these areas. It's quite a big topic to go into and not something that we could cover, unfortunately, this evening. So in summary, I hope that you'll agree valid consent it's essential to good medical care. The information that we need to share with patients must be tailored to their needs, and in order to do that, we need to have had that discussion with the patient to find out what their needs are. The latest GMC guidance puts this huge emphasis on the role of dialogue and discussion with patients. And it requires us to have an individual approach to explaining treatments and procedures to all patients. Again, those following the GMC guidance will likely already be fulfilling the requirements set out in Montgomery, i.e. the legal requirement for consent. That's all the slides that I have for this evening. We've now got hopefully a good 20 minutes or so to try and answer some of your questions. So I'm going to stop sharing my screen and hopefully my colleagues will still be there. Yes.
Hi Nikki, we've had lots and lots of questions in the coming through in the background, so we've picked on some of them. We've done our best to answer as many as we can, but apologies to those if we haven't got around to you. I've got a question here from a consultant anaesthetist, and they've said they're often working on the delivery suite, particularly worried about consenting for procedures about labour, including analgesia such as epidurals, and providing spinal blocks in an emergency situation. Not least because the first time they encounter these patients to discuss, what needs to happen is usually when they're already in pain and very distressed. So how to go about this? How do you suggest incorporating the new guidance in this scenario?
Gosh, I do appreciate that. It's a hugely pressured environment. Really, the GMC does help us a little bit in that it says that we should be adopting this proportionate approach. And when we consider what information we need to share, we need to look at the urgency of the treatment and how quickly it is needed. Clearly, you don't want to jeopardise or risk the patient getting the necessary care or delay that. But it's about being able to weigh up the urgency of the situation whilst giving as much information as you can. Do any of you want to expand on that at all, or?
No, I agree.
I think I answered a question like that. There were a few versions of that question, and one of the things that seemed reasonable perhaps to add in was that there may be opportunities to provide information and answer questions in the period running up to the delivery suite. So providing all information to a patient, giving them a chance to meet with people who may be treating them or from that speciality, and answering any questions they might have. It's another example. I've got one here, which is also an anaesthetic question. It's, do we need to disclose all the serious side effects of all the medications used when consenting for a treatment? For instance, multiple drugs used in anesthesia, all of which can have serious side effects.
I think that's a tricky question, but clearly an anaesthetic is a thing in the whole, and you will be discussing the risks associated with the anaesthetic as a whole. Certainly if the patient asked you specifically about each drug, so you would need to tell them about the complications associated with those drugs. But equally, I think you need to put them into context as well about you know, what is the risk associated with that specific drug? What is the benefit of using that drug as well? Because although all these drugs have their risks, they also have specific reasons why you use them, and specific benefits in certain patients. So, you know, if there's a direct question, I think, from a patient about what is the risk associated with this drug, then you can't not answer that. But otherwise, I think you're answering about the anaesthetic as a whole in relation.
Yeah, I think I tried to say something like that as well in the answer I gave to the person who asked the question, or one of the questions anyway, about you're talking about the whole the anaesthetic as a whole, and there are rare but serious side effects of the anaesthetic, may not be easily ascribable to one drug or another, and it's the awareness of the risks of that in the context of the overall risks of what is going on.
Yeah. Okay.
Great. So I've got a few here. Firstly, I think a really interesting comment that I've got here saying that in 2021, the emphasis still seems to be about doctors avoiding litigation rather than sharing partnership with patients and allowing them true choice and autonomy. Why do we not develop discussion tools rather than the side effects checklist? And this still seems to be a rather defensive approach. Now, the thing I'd say about that is I absolutely agree. I think that's the challenge in the GMC guidance, is to develop these sorts of tools. And I know there are a lot of people out there doing this work, using computerization, being able to share resources and to share that. I guess in answer to your question about why we focus on litigation, I guess inevitably through what we do at the MDU, we become involved when there is a dispute, and those are often also the questions we asked. But you're absolutely spot on that really that's the challenge we have, is in developing those tools to engage patients better. Any other sort of comments on that? And I've got two quick questions after as well.
No, I agree. I think that's... Yeah.
The other two quick questions is there's one here in two different areas. One is about a 16-year-old foster child needing a scrotal procedure. Who could be consulted for consent? Biological parents, social services, foster parents can consent in an emergency. My observations on this one is that the 16-year-old, if they're sufficiently mature, may well be able to give their own consent. And in most parts of the UK, a 16-year-old is considered able to consent to their own medical treatment in law. So that's relatively straightforward. I think there's a broader question here about looked after children, and often, you know, if it's an emergency, you may well be able to proceed in the child's interest. If not, then the social services may well have parental responsibility or be able to guide you as to who does, who you can approach for consent. And this one I'd like your input on as a panel, to say that I've got a question from a doctor about day case procedures, asking about one-stop procedures like vasectomy. Can they consent for that without a prior consultation with risks and benefits discussed on the day? What do you guys think about that?
Nikki, do you want to go? Or I mean, I'm happy to have a go at that. I think that for relatively straightforward surgery, in which you're able to provide lots of information in advance beforehand, for instance, like a vasectomy, which will have been discussed with the patient, perhaps in the general practice, there'll be a sharing of information. It may very well be reasonable to meet with them to discuss what you're going to do and to go through questions in that context at that point. I don't think there's any need for multiple opportunities to meet with them in that circumstance, because it's a relatively straightforward thing. There may be situations, there may be patients who do need more than one consultation, even for a vasectomy. So you can't say it's going to work for everybody, but I think if the patient's happy, they've had an exchange of information, they've asked the questions they want, you've taken notes, you've written that down, and you can evidence what you've done, I think that's pretty reasonable.
Yeah. And then, you know, when you see that, sorry, Nikki, go on.
It's all right. No, Sam, you go on. I'll chip in after you.
And then they've got the opportunity, if, when they get there, to have a last quick talk and, raise any concerns. And if there are any doubts, then they've got the opportunity to ask about them or to defer, so they're not under, undue pressure.
Yeah, that's pretty much what I was going to say, Sam, in that if you then have concerns when they do turn up, that they still have doubts and they're still not quite there, then you just have to defer. But it would seem to be the sort of procedure that quite a bit of information can be given pre-operatively, and then you can address the questions on that day.
Thank you. I agree. I think the key is what you mean by what consent you're taking there, in that if this is about the decision that this is the right route for that patient, that they want to have a vasectomy as their mode of contraception, I think that discussion should not take place, obviously, on the same day as the procedure. If you're talking about technical complications and things about which they've already had information and been able to digest, then I think that's a reasonable approach.
Mm. Yeah. I've got a couple of questions that have come up about recording, both by the patient and the doctor, and I know this is a challenging topic, isn't it? So if a patient records a consultation on a phone during a consultation without the GP's consent, it's covert recording, is that okay? What can they do about it? Is it admissible as evidence in court? This is the question that's been asked. How can that information be used if they have a concern and want to use it as part of their concern? And then on the back of that, one of the delegates said, can a doctor record? Sometimes we're aware that patients record covertly, but what about a doctor? Can a doctor record?
So a consultation, the information that's shared in that consultation is the patient's information. The patient can record that consultation. Ideally, it would be good if they let the doctor know that they're going to do it, but I don't think you can stop them doing it covertly. How they then use that information is generally their own choice. It's their information. In terms of a doctor covertly recording a patient consultation, that would go against GMC guidance, which says that if you're making recordings of patients, that you need to seek their consent for that.
Can I just add to that briefly, in that I think there's a question about admissibility in proceedings as well, wasn't there? And I think unfortunately, we know the answer to that. I think the case was Flower, but it was where claimants, was being examined by the defence expert and covertly recorded the assessment, including comments that were made after the assessment had ceased that were helpful to her claim, and the court did allow that in there. The other thing, the reason why this is so frustrating, and I know it generates a lot of anger, and I'm sure we've pretty much all been covertly recorded, but the problem is that in terms of data protection, the emphasis is always on access to information, and those obligations are asymmetrical. So if we're doing something in a professional capacity, if we're at a hospital and we're recording, of course, the hospital's data controller, it's got to get proper consents in place for recording, tell people they're doing it, and establish rights of access to that recording. There is an exemption in the Data Protection Act for your social and pleasure use. So if you've got a database on which you put names of people you're going to send Christmas cards to, that doesn't need to be registered. So unfortunately, that's the way it's been for a very long time. I know it's quite frustrating, but that's not a kind of position that I think is very likely to change.
I've got one that's just come in from a trainee, a GPST1, who's doing a course on minor surgery and with the intention of being trained in minor surgery as a GP. And the course material suggested that they don't need written evidence of informed consent and the verbal consent would suffice. But it's recommended that it's documented also that there's been some form of consent. What is the right approach there? Do they need written consent for all minor interventions like minor surgery?
There isn't a requirement for the patient to sign a form to say that they provide their consent, but I think in terms of evidencing that discussion that you've had with the patient, it's helpful for you to have written down what discussions you've had with the patient and what information the patient has shared with you. But there isn't a specific requirement that they have to put their name on a form.
Yeah, I mean, I think one of the things I would say is that surgery as well, the surgery that would appear minor at first impressions can turn out to be more major than you expected. And I think that going through things properly and certainly documenting the fact that you've had a discussion with them is certainly the right way forward, if not necessarily filling in a particular consent form. Sam, do you have anything?
Yeah, no, just following on from that, someone said, you know, that there's a few questions I've noticed about how can we evidence meaningful discussion? And I think that's problematic, and the consent form could be a part of that, can't there, along with other things that you can write as part of, you know, a detailed record. I don't know what anyone else thinks about that.
Sorry, the consent form certainly forms part of that, and any sort of complications that you might have discussed with the patient and risks and benefits. But in terms of evidence and meaningful discussion, I think there was that slide there that thinks about documenting what the patient's concerns are about a procedure, what their specific expectations are about a procedure as well, along with the various benefits and risks that you've documented there. That shows that you've at least had that discussion, tried to find out more about the patient. I don't think do any of you have any other?
I think it kind of feeds into another related question, which was somebody asked about procedure-specific consent forms, which have been pre-filled in with regards to particular risks of procedures, and of course that kind of goes against what we've been talking about, which is what is important to the patient and what the patient might want to know. So that they may be helpful to start a discussion, but they're not going to be adequate evidence that everything the patient wanted to discuss has been talked about.
Yeah, I think they're great aide-memoirs, I think, in terms of a starting point, but they've got to be individualised in terms of evidencing that you've considered the particular patient.
And I think actually a lot of you will do this already. You know, when you have your clinic letters sort of talking about what problems the patient's experiencing, what their worries are. I mean, you know, the only thing I generally take consent for is for liver biopsies. And when I talk to patients, I will record in the letter what their concerns are. So there'll be some patients whose priority is to avoid having invasive management. There are others who want more certainty in their diagnosis, and that sort of thing. Talking about what the priorities are and what you would do to deal with that is part of that sort of meaningful discussion. So I'm going to deal with another gastro question here. It says, when nurses consent patients' procedures such as endoscopies, do they need to ask the doctor to vet and confirm the consent? I think that's a situation in which the consent has been delegated to that nurse. If you're doing the procedure, you're still obviously required to be satisfied that proper consent is in place. So it's not so much that they have to ask you to vet the consent form, but you should be satisfied that the patient has consented appropriately. If you're happy that the consent process is robust, you may be able to do that by simply just asking the patient whether they've got questions, confirming they know what they're there for, and proceeding.
Okay.
Right.
So I'm scanning through some questions here. There's quite a lot. We've covered quite a lot. There's still, I think we've got a few minutes for a few more, haven't we? There's a slightly different question here that I've just seen from a surgeon. I know it's been probably covered, but we'll raise it again. How do you proceed when the surgeon thinks a patient without capacity is not fit for an operation because of high mortality and morbidity, not able to be extubated afterwards, etc., but the family wants to proceed with the operation? Difficult, isn't it?
It is a difficult situation. You've got to act obviously in the patient's best interest. The family should be involved in that decision-making process, and certainly anybody with a power of attorney or some sort of appointed advocate should be involved with that. If there's dispute as to what is appropriate, then it's helpful to try and get everybody together, get a meeting, and try and do that a best interest decision meeting approach to try and get some sort of concordance and to explain what your thoughts are on the process. ultimately, if there's still disagreement, then it may be something that might need to be taken further, taken forward, and involve your legal team. But it's a very difficult situation.
But I guess the point is, or one of the points for you and I as surgeons was when people were keen for somebody to have an operation and we did not feel it was in their best interest, we weren't obligated to provide that operation. We were able to discuss it and to set out our concerns and try and talk through why they wanted something. But we would often perhaps ask somebody else to come and give a second opinion on whether our approach had been reasonable. Ultimately, we didn't have to give in to requests for treatment. Right, where are we? There was one question about how you ascertain that somebody has actually understood the discussion that has taken place. How do you evidence that they understand what's being discussed? And that's actually quite a challenging one, I think. Any comments on that?
I suppose it's easier if you're going through a process rather than just meeting on a one-off, in that you might have explained it to them on a first instance, and then perhaps when they come back, you ask them
so why are you here, and what do you remember what we're going to do, and why were we doing it? Do you remember how we're going to do that, and the approach that we're going to take, and why we're taking that, and then getting them to talk to you about what you're going to do and why? It's a good way of then demonstrating understanding. You've got to be. You're not expecting them to understand at the level that you would perhaps as a clinician or as a surgeon, for instance, but you want them to have a good layman's understanding, certainly, and be able to express what you're planning to do. I hope that answers the question from my point of view. Ed, do you want to add anything in, or Sam?
Go ahead.
Okay.
Okay.
So there's an interesting one here, because I think it illustrates a few different points about what happens when a patient with multiple comorbidities and high surgical risk still insist on surgery. All objective assessments show high mortality and morbidity scores and poor outcomes. I'm a geriatrician who works in perioperative medicine, and the multidisciplinary opinion is patient will be a poor candidate. Is the desire to go ahead still a valid decision? And then how does lack of insight affect consent? So I think there are a few different concepts here, aren't there? In that, of course, a patient's consent is necessary for the treatment, but it doesn't necessarily oblige you to go ahead. The case was really that sort of established that was Leslie Burke and his insistence on having a peg feed if he became incapable, whereas there's a declaration to say doctors aren't obliged to provide treatment that's clearly not in a patient's interests. Now, there will be other circumstances where the interests are finely balanced and the patient may be extremely high risk, but makes a perfectly valid decision that they'll accept the risks. I think your question about a lack of insight is really touching on the issue of capacity, which is, obviously a separate but obviously a very linked issue. So I thought that was a really interesting sort of scenario that is possibly becoming increasingly common. Any sort of comments on that?
No, I think it's very similar to as Jared said earlier. It'll be one of those where you'd probably want to try and get a second opinion and get the patient on board that way by trying to help them to get that insight and understand the reasoning behind your clinical thought process. But again, you can't be forced to do something that you don't feel is outside of the patient's best interest.
There's one. I think we're actually getting quite close to time, aren't we?
I think we're very close to time now, actually.
I'm sorry, we haven't managed to get through everything. As often happens, there was a flood of questions towards the end. I'm sorry about that.
Okay. Well, I think we're going to wrap up now, and so we'll say thank you very much for joining us. This webinar hopefully should be on our website very shortly, and your certificates of attendance should be coming through the post to you very soon. We equally do have lots of other educational videos and such on our website, so please do have a look at those. Thank you very much. Good evening. Sorry, Jared, did you want to say something?
I was going to say one extra bonus is that we are going to do another video where we go through these questions that we haven't answered and try and answer some of them for you. Because there's an overspill from the last one as well, and we recognise that a lot of you haven't had the questions answered you wanted. So we'll do our best to address these in the next couple of weeks at some point.
Okay.
Thank you very much.
Thank you.
Bye-bye.